Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm in the Denver area, and wanted to make a video about one of the earliest decisions that you need to make when you're opening a probate process, and that's whether to open it formally or informally. And the ultimate goal of probate either way is really the same, right? We want to find the beneficiaries, we want to find the creditors, we want to make sure the right stuff gets to the right people, and that everything is correctly wrapped up when we're done, and that the people who have received their funds can go on with their lives and be sure that nothing's going to pop up later down the road. No IRS bill is going to show up. There's not going to be any creditor who shows up that was not found at the right time. There isn't going to be anyone saying that they, didn't receive what they were supposed to receive. The probate process is supposed to take care of all of that and kind of give you a certain ending. But there are a couple different paths in Colorado to get there, and they are the formal or informal path. So the informal path just means really the court is assuming good faith throughout the process. And what that means is they're really not going to do anything proactively. The person who serves as the personal representative, they file that application. They provide the details to the court. They say who died, when that person died, where they were living, who their heirs were, all those kinds of basic details that a court would need to know to make sure that this is done correctly. And then from there, the court wants to see that the heirs are correctly notified about the probate process so that they can be aware that it's taking place, that they may have rights that they want to assert, and that where to go to assert those rights if they need to do that. And so what happens is an information of appointment goes out. That is a specific document letting them know all these things. And then the other thing the court wants to see is that the creditors get correctly notified. And depending on exactly when this is happening in relationship to when the person passed away, there are a couple different steps that may need to be taken. And also depending on what bills have been received and what the personal representative already knows. Because there are creditors out there that usually the personal representative does know about, and then there might be creditors out there that the personal representative does not know about. And so there's a couple different steps there. And again, both informal and informal probate processes, these kinds of things happen. But in the informal process, as long as those notifications get sent to the beneficiary and the creditors, the court then kind of sits back and just assumes that if they're not hearing any complaints, those people have been notified. They know where to come. They know the case number. They know at least that they have some rights, whether they know exactly what those rights are. But they can, if they have an issue that they want the court to hear and rule upon, they can assert those. And if they're not doing that, the court just assumes that things are going fine. And like I say, that the personal representative is operating in good faith. The formal process, there is a little bit more activity, and there are a few more steps you need to take. When you set up a probate in the informal process, you just kind of do it. The clerk rubber stamps the letters, which is the document that the personal representative needs to go around and collect assets and let people know that they've been appointed by the court to do this job. With a formal process, you are supposed to schedule a hearing. You're supposed to let the court know, and then let those beneficiaries and potentially creditors know when this hearing is going to be, so that they can actually show up and object if they feel like things are not being handled correctly, or if the person who applied for personal representative is not the right person, or if a will that has been submitted for the probate process is not the right will, those kinds of things. And so from the personal representative's perspective, obviously the formal process, a few more steps, a little bit more bureaucracy, a little bit more chance that there's, going to be somebody who shows up and actually, objects to various things. So that all may seem very unappealing. But the appeal of the formal process is just that, again, you're actually gonna have court involvement there, and you're gonna get some answers, and you are gonna be a little bit more sure that everyone's been given a fair chance, and if anybody had a complaint, they definitely had a time to assert it, and it just cuts off your liability a little bit more clearly and a little bit sooner. And so Sometimes the formal process, if you're expecting a creditor issue, somebody's asserting something that you don't think is right, if you're expecting that the estate's going to be insolvent, that it's not going to have enough money to actually pay its bills, if you're expecting that there's a beneficiary that's going to be difficult, if you're going to submit a copy of a will for probate as opposed to the original, really we want the original copy, the original version of the will that was actually signed by the person and the witnesses and the notary. If that's not happening and a copy is being submitted, you actually do have to open formally to give other people a chance to say, hey, wait a minute, that copy is not the most recent version. It's a copy because the decedent actually destroyed the original because they didn't want it, like all those kinds of things. So there are certain circumstances where having a formal probate is actually desirable. There are certain circumstances where you have to open formally. So like I say, it's not a whole lot different to open formally than informally. Like I say, you schedule a hearing. In Colorado, it's called a non-appearance hearing, and what that means is that there actually is not a hearing on the date scheduled. The non-appearance hearing date is just the date by which the people who then get notified of it, that's the deadline by which they have to actually submit a notification to the court that they are going to object. And if they don't do it by then the court proceeds. And one other note is that you actually can open an estate formally and then close it informally, or vice versa. And again, on closing formally, same thing, a couple more steps, a little bit more court involvement, a little bit more process you got to go through. But the benefit of closing formally, again, cutting off liability. If you close informally, really the court just rubber stamps it. And that's kind of nice because it's fast and convenient, but again, your liability kind of continues on for up to a year after that. Whereas if there is a formal closing and people really were notified and really given a chance to object with a deadline given to them, your liability can be cut off much sooner, at about 30 days. So that's the difference between the two. I would say most probates probably are informal. Most probates, the reason they created the informal process was because they realized, there's a lot of probate processes going on out there, and there's a lot of supervision happening, and frankly most probates, despite what you hear about the bad ones, probably are going fine. The beneficiaries are probably generally agreeing there really isn't that much that the court needs to do, so let's just have this informal process available. And like I said, I think that probably covers most situations, but obviously there are situations where more court involvement would be beneficial, and so you may want to consider using the formal process in those circumstances. So if you're working through this problem, of course, we're happy to consult with you on that. Again, we're the McKenzie Law Firm. We're in Denver. Our phone number is 303-578-2745. If we can be helpful, reach out. We're happy to talk. So thank you for watching this video. I hope it was helpful.